I'm Tony from Monarch Law in Connecticut. I'm an employment attorney. I want to give an update on this bankruptcy issue that's going on in one of my cases. It's an age discrimination case in federal court. There are two defendants, a corporate defendant and an individual. Now, the corporate defendant filed Chapter 11 bankruptcy in Texas, and I wanted some clarification from the court whether or not the pause of my case applied to the individual defendant. And the court recently ruled and said, yes, it does, because the claim I have against the individual is an aiding and abetting discrimination claim based on state law. And there can't be an aiding and abetting without that primary claim against the corporate defendant, the employer. So I'm out of luck. So what I did to protect my client is I filed a proof of claim to preserve her rights. And so if there is any money coming out of the bankruptcy, she'll be identified as a creditor. It doesn't mean I won't try to lift the stay. In our case, I might argue to the bankruptcy judge that the stay should be lifted because the corporate defendant has insurance. And what I'm hearing from the other side is there's a high deductible that the corporate defendant is responsible for paying first and it can't afford it. And that's why the stay is proper. I'm not going to take his word for it. We're going to put them to the test. I'll be back with another update. If you have employment law questions, you can call Monarch Law.